Looks like everybody can hear me because they're waving and smiling. That or I'm doing something wrong. Well, good afternoon. Glad everyone could join us, or most everyone could join us today. Let's see. Oh, I just did something. Didn't want to do it. Okay. So are we, I guess we're ready to get started. Keep doing things that are not. There we go. I get it. So we're ready to get started. With that, I'll just mention, welcome everyone who's coming in virtually to the fourth commission meeting of 2022. And you know, I want to provide a brief update on the importance of the Safe Communities Act, Bipartisan Safe Communities Act that was signed by President Biden last month. It was designed to address, or at least start to address, some of the gun violence that we've been seeing and fortunately have had to deal with. But it has a number of provisions that provide funding to the states to address mental and behavioral health issues, help our efforts in that regard. It created a program called the Crisis Intervention Program with $750 million in grants to states to implement crisis intervention court programs under the Justice Assistance Grant Program. And it provides federal justice funding, criminal justice funding to states and local jurisdictions. And it states that the funding could be used for, among other things, mental health courts, drug courts, veterans courts, as well as, and I'm putting emphasis on this, assisted outpatient treatment courts, or AOT courts. And so that we found that quite interesting, and we'll be having further discussions with our health department and others with regard to the AOT courts or any of the others. I know a number of jurisdictions have mental health, drug courts, as well as veteran courts, but we can see what we can do in the area of AOT as well. The law also provides $1 billion in funding to states to administer competitive grants to high-need local educational agencies for providing services in the areas of mental health, or I should say providing resources for mental health, challenges for drug and violence prevention, crisis intervention, as well as high-quality training for school personnel on suicide prevention and human trafficking. And there's $250 million in funding to increase SAMHSA's Community Mental Health Block Grant Program that provides states with funding, flexible funding, to provide comprehensive community mental health services. And then as well, $50 million in funding for technical assistance for states to improve access to mental health care in our schools by implementing and expanding school-based health programs, and that's under Medicaid. And then the law instructs the Centers for Medicare, Medicaid Services, and the General Accounting Office to review and provide assistance to states regarding implementation of Medicaid early and periodic screening, diagnostic, and treatment plans or treatment benefits. And for CMS to provide guidance to states on how to increase access to healthcare, including mental health services via telehealth under Medicaid and under the Children's Health Insurance Program. And as well, it expands Medicaid Certified Community Behavioral Health Clinic Demonstration Program. And we're very much hoping that this additional funding will help in our efforts to really address and try to work to improve our mental and behavioral health delivery system for the betterment of all of our Marylanders. So with that, I'll move to the agenda. And that was my initial remarks. And so now I'll call the names of the members, and I ask that you take a moment and introduce yourself as well as state the organization that you represent. So I will start with Senator Adelaide Eckert, also known as Addie.
Thank you very much, and good afternoon, everybody. I think I'm the Senate appointee to this commission, and thank you very much, Lieutenant Governor, for sharing all that good information, because we do need help in many different areas, particularly here on the Eastern Shore. I'm in the middle of the Eastern Shore, so my major concern, as you well know, is services on the continuum throughout the shore and ultimately the state. Thank you.
Thank you. Okay. Senator Hester.
Hey, good afternoon, everybody. This is Brandon here on behalf of Senator Hester. Unfortunately, she couldn't be here due to a family emergency, but I am here on her behalf. Also as a Senate appointee to the commission, as a mom and someone who cares deeply about our criminal justice system, healthcare is major priority. Mental and behavioral healthcare is a major priority of Senator Hester's. So that's why we're here.
Okay, thank you. And Delegate Kelly is not here. Delegate Young.
Good afternoon, everyone. Good to see you. Delighted to be here, and I'm glad to see that we have a proposal on the danger standard regulations on the agenda today. Some of you remember I had a bill in this session on AOT that certainly overlaps with this topic. Very eager for the discussion. I sit on HGO for those of you that are new today, and I represent Frederick County.
Okay. Yes, I was going to ask you about that, but about your legislation and just any of the issues that came up, but we could wait until we have that further conversation with regard to the danger standard. Okay. I believe I got a note that Director Abbott will not be able to attend. Trisha Roddy.
Good evening, good afternoon, Lieutenant Governor and other commission members. I'm Trisha Roddy. I'm the Deputy Medicaid Director for the Maryland Department of Health, and I'm glad to be here this evening.
Okay, very good. Dr. Burgess.
Good afternoon, Lieutenant Governor and other members. My name is Dr. Lisa Burgess, and I am the Interim Deputy Secretary of the Behavioral Health Administration. It's great to see everyone.
Okay, good to see you. Lieutenant Colonel Butler.
Good afternoon, everyone. Lieutenant Colonel Roland Butler. I am the Chief of the Field Operations Bureau, representing the Superintendent, Colonel Jerry Jones.
Thank you. I think Dr. Beneski is not available. Tiffany Rexrod.
Good afternoon, Tiffany Rexrod, Executive Director for Local Operations with our Department of Human Services.
Thank you. Let's see. Catherine Barain.
I'm Mary Quay. I'm attending on behalf of Commissioner Barain from the Maryland Insurance Administration.
All right, thank you. Robin Ricard.
Good afternoon, everyone. Robin Ricard, the Executive Director of the Opioid Operational Command Center. It's good to see everyone, and I'm really excited about looking up, as soon as we're done, the Safe Communities Act, because you know that I love drug courts. I've never heard of an OIT court. So I'm really looking forward to it.
But I know we had talked about that as Delegate Young had just mentioned. I'm not sure, what we can talk about that further and do some research. I have some guesses on what it would be. Okay, but thank you. Christian Mealy. Is Christian here, or is anyone here representing Department of Disabilities? Okay, moving on. Mary Gable.
Good afternoon, Lieutenant Governor and others. I'm Mary Gable. I'm with the Maryland State Department of Education and work directly with student services. Thank you.
Barbara Allen.
Good afternoon, everybody. I'm Barbara Allen. I'm a family and advocate, family member, and I am the executive director of James Place. We're a nonprofit. I also chair the Howard County Opioid Crisis Community Council.
Thank you, Barbara. And Patricia Matuszewski.
Thank you, Lieutenant Governor, and good afternoon, everyone. Pat Matuszewski here. I am a family advocate with lived experience, and I'm also a registered nurse.
And Dr. Triparani.
Hi, good afternoon, Lieutenant Governor and everybody else. Glad to be here. I'm an Associate Medical Director for Mid-Atlantic Permanente Medical Group.
Okay. Carrie Cho.
Good afternoon, everybody. Lieutenant Governor and all commission members. I'm Carrie Guthrie Cho, the CEO of Cornerstone Montgomery, a behavioral health nonprofit in Montgomery County.
Okay. Kimberly Watts.
Hi, I'm Kimber Watts. I'm an attorney with the Office of the Public Defender in our Forensic Mental Health Division.
Okay, and I think Serena Eckwood said she wouldn't be able to attend. Okay. All right, thank you. I know we sent out the minutes. I think they were sent last week. I don't know. I hope everyone has had a chance to review them. I know they're very detailed minutes because they're kind of kept electronically, and then we go through them and try to correct the areas where the electronic voice recognition doesn't quite catch it completely, and it's a lot more detailed than when we have a live person taking them down. So it takes some time to review. I know it takes me time to review them. But I just want to ask if anyone has any questions or objections before we approve the minutes. Okay, can we get a motion to approve?
So moved.
Do we have a second?
Second.
Those in favor can say aye or raise your hand, or both.
Aye.
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 Any opposed? Okay, minutes are approved. We'll then go to our subcommittee reports. And we'll first start with the Crisis Systems Advisory Workgroup. If anyone from that particular work group.
Dr. Burgess, do you have that?
Let me see. I was down today to give a report on the involuntary commitment work group, but I can give you some update on that work, or we can table it until the next meeting. Lieutenant Governor, let me know.
If you prefer, that's fine.
Let's do that. We'll make sure that we have it for you at the next meeting.
Okay. Youth and families. I know Christian often, I think there's co-chair.
Yes, good afternoon.
Okay.
Happy to give the report on behalf of our committee.
Thank you.
The Youth and Families Subcommittee held its last meeting on Monday, June 27th. In honor of Pride Month, Rowan Willis Powell from On Our Own Maryland provided a presentation on supporting diverse populations, LGBTQIA+ youth in Maryland. We appreciated the focus on terminology, sexual orientation, gender identity, and gender expression. The presentation also included information and resources on ways to help and support LGBTQIA+ youth. The subcommittee also began an early discussion of our 2022 recommendations. The conversation focused around gaining a better understanding of youth service utilization across programming around the state and expanding awareness of the mental health advance directives. We will be continuing these discussions and adding to our recommendation list at our next meeting. The next meeting of the Youth and Family Subcommittee is scheduled for August the 8th, beginning at 1 p.m. We plan to have a presentation focused on school-based mental health and safety in the wake of multiple mass violence and trauma events. Thank you.
Thank you. I have a question. What does the IA stand for? And you mentioned that there was discussion on definitions and terms. LGBTQ plus IA.
I think it might be intersex and asexual, but I don't know off the top of my head.
That's my understanding too.
Okay.
I agree.
All right. Okay. Having a hard time keeping up. Sorry. Okay. Financing and funding. Subcommittee.
I'm happy to give the update. Of course, you know, the Finance Subcommittee is chaired by both the Medicaid team as well as the MIA. So I'll hand it over to Mary after I give my update on the Medicaid pieces. We met yesterday, the subcommittee met yesterday, and we're meeting again on September 8th. We talked yesterday about the work that we're doing with the system of care integration and optimization work group. We've met a number of times with the work group. The focus has really been on receiving comments around the new request for proposal for the new behavioral health administrative services organization work. A lot of the discussion has been around and focused on the need for care coordination. And while I can't share the details because of procurement rules and laws, I will say that because of the feedback that we received, care coordination will be a main functional area of the RFP work. In addition to discussing the ASO RFP, we have continued the discussion on how to share data between our managed care organizations and the ASO. Right now, there's a number of different barriers that are happening. A lot of them have to do with, the ASO itself. So we're looking at alternatives like using our Health Information Exchange, CRISP, as a way to exchange information, again, with the managed care, the 9 managed care organizations. And then there is a lot of work going on within Medicaid as well as the Behavioral Health Administration on implementing a number of new services over the next year. The governor funded 3 main services in the Medicaid budget. We are covering peer recovery specialists under Medicaid. And then 2 additional new services are mobile crisis, as well as crisis stabilization units. Not much to report out other than that we're meeting a lot in terms of developing the provider qualifications, the policies around these new services, and also developing the provider rates that Medicaid will pay. We have hired health management associates to help us with the mobile crisis and crisis stabilization unit work. So there's been a lot of progress being made. We are going to be planning on meeting with stakeholders too to get their feedback on the work so far. So more to come on that, but the regulations and the state plan amendments will probably become effective sometime between January and June of next year. But again, the team has been really focused on implementing those services. So I will hand it over to Mary, and then we can both be available for questions.
Thank you. And good afternoon. I'm Mary Quay. I'm the Associate Commissioner for Market Regulation and Professional Licensing at the Insurance Administration. And as we've talked about before, for mental health parity, Section 15144 of the insurance article required filings of reports on compliance with the Mental Health Parity and Addiction Equity Act, specifically with regard to certain categories of non-quantitative treatment limitations, which include things like provider reimbursement rates. The filings were due on March 1st. Some filings were late, and the MIA has issued one order and is working on additional orders against carriers that filed late. The review of the filings is underway. We currently have a contractual employee working on some of them. The review is detailed and time-consuming. We are sending out the deficiency letters beginning this month, but it will be a slow process. We know that the federal government and other states have found that initial filings on this topic are usually incomplete or insufficient, but we are trying to give detailed explanations of the deficiencies to assist carriers in supplying all of the needed information to determine if they are complying with the law. In the future, we will be considering orders with penalties for not filing complete reports, but our concern now is to obtain enough information to know if the carriers are complying with the Parity Act. I have a couple of updates as well for network adequacy. The annual filings were due on July 1st, and the summaries will be on our website this week, although they may be subject to revision based on further review. I believe all of the companies filed when due. We have drafted changes to the network adequacy regulations. The draft proposed regulations were posted on the MIA's website on July 7th. The comment period closes August 8th. The goal of the changes is to obtain reports with more useful and complete information, including the use of consistent methodologies. The MIA has hosted public meetings on the regulations and has carefully considered the comments we received. In particular, we have been concerned with the best ways to incorporate the use of telehealth in measuring network adequacy. Telehealth can be an important component of delivering care to people in underserved communities, but there are concerns about infrastructure and accessibility. And those are our updates. We will be continuing our review of the reports.
Okay. I think from some of our public meetings we've had before, network adequacy might be an area of concern for a lot of the relatives and organizations. But we'll see what additional comments, and be interesting to see what your review finds. Okay, any questions about that? The report from the Finance Committee. Public safety and justice system.
Yes, good afternoon again, everybody. Brandon here from Senator Hester's office to provide a quick update so that we can move on to the extremely important presentation and discussion on the dangerousness standard. The Public Safety and Justice System Subcommittee remains committed to supporting and overseeing the activities of the Behavioral Health and Public Safety Center of Excellence. And to that end, we plan to invite them to a public update for or on their plans and activities from the prior year and the upcoming year at our next subcommittee meeting. That will be on Tuesday, August 2nd from 12:30 p.m. to noon. We understand that they plan to hold another SIM Summit and Train the Trainers event later this year in accordance with their establishing legislation, as well as a CIT planning and implementation meeting, but we'll have additional updates for you during the next full commission meeting.
Okay. Well, thank you. And yes, as you just mentioned, we will be looking to a presentation that we're having with regard to the Maryland Danger Standard Regulations. I'd like to welcome Secretary Dennis Schrader and of course, Lisa Burgess, who introduced herself, will be making the presentation today. So Secretary Schrader.
Thank you, Lieutenant Governor. Can you hear me okay?
Yes, absolutely.
Right. And I think, there we go. I'm going to introduce Deputy Secretary Lisa Burgess from the Acting Deputy Secretary for the Behavioral Health Administration. She has taken over from Dr. Leah Jones, who has gone over to be a part of the Luminous organization and responsible for their behavioral health enterprise. So we're very happy for her, but we're also delighted that Dr. Burgess has agreed to take over, and she will be giving the presentation on the involuntary commitment and dangerousness standard in Maryland and what the action plan is. So Dr. Burgess, do you want to go ahead and take over?
Thank you, Secretary Schrader. And thank you, Commission, for allowing us to give you an update on this, the work group. And so, as you can see, this update will be about the involuntary commitment and the dangerousness standard in Maryland. Next slide, please. So then the statutes and regulations for involuntary civil commitment in Maryland, the dangerousness standard has led to a wide interpretation of the law on involuntary civil commitment for hospitalization. And this dangerousness standard is as follows. The language: the individual presents a danger to the life or safety of the individual or of others. And through this commission, the Behavioral Health Administration was asked to review Maryland's current involuntary civil commitment laws and regulations with a focus on examining the dangerousness standard language. BHA led a diverse group of stakeholders in hosting 4 involuntary commitment work group meetings from March to April to better define the language of involuntary civil commitment. Next slide, please. The Involuntary Commitment Work Group reviewed current Maryland statutes and regulations on civil commitment. Both of these contain the same dangerousness standard language. The work group reviewed a wide range of perspectives on involuntary civil commitment, including from Maryland stakeholders and national organizations. The work group ended up proposing specificity to the dangerousness standard within the involuntary civil commitment COMAR regulations. Next slide, please. So looking at excerpts from the Maryland statutes, we have Health General 10.616. And when you look at the rules and regulations,
10.617 adds that a facility or Veterans Administration hospital may not admit the individual under this part unless certain needs are met. Again, the individual has to have a mental disorder. They need inpatient care treatment. If you look at number 3, it's the same, it's a dangerousness standard language that we referenced earlier in this presentation. And then following that, the individual is unable or unwilling to be admitted voluntarily, and there's no available less restrictive form of intervention that exists. Could you please go to the next slide, please? So Maryland regulations interprets the statutes as follows. An explanation is needed of why the individual meets the following requirements for involuntary admission. And so again, it will look very familiar. A mental disorder is needed for diagnosis. You need the medical history. You need an explanation that the patient meets the following, the individual. The mental disorder needs inpatient care. And number 3, again, mirrors the statute language. The individual presents a danger to the life or safety of the individual or of others. And then following, the individual is unable or unwilling to be admitted voluntarily, and there is no available less restrictive form of intervention that exists. Please go to the next slide. Through the work group, proposed language was introduced. For an individual to meet the requirements as presenting a danger to the life or safety of the individual or others, the individual shall experience an incident that is recent and relevant to the danger which the individual may currently present, arises as a result of the presence of a mental disorder, and includes but is not limited to one of the following scenarios. And various scenarios are listed. So for example, the first one, the individual has threatened or attempted suicide or has behaved in a manner that indicates an intent to harm self or has inflicted or attempted to inflict bodily harm on self or another. And so there's 2 that follows, but again, I'll go back to the initial statement that this includes but is not limited to these scenarios. Next slide, please. And so the next steps in this timeline is that August 12th, the proposed COMAR regulations are scheduled to be in the Maryland Register for public comment. September 12th, the period for comments will close. And November 12th, there will be a review and incorporation of comments completion. We do continue to welcome and encourage comments. Instructions for where comments should be sent will be found in the Maryland Register. And that ends our presentation, but certainly we're open for comments and questions. Thank you. And questions or comments? So thank you, Lieutenant. We do see hands. Okay, great. Delegate Lewis Young.
Thank you so much.
Recording stopped.
One concern I have is that there's nothing that explicitly states that imminent danger is not a requirement. And I think we need to make that really clear. Otherwise, and looking at 2 components of the recommendations, there is a suggestion that imminent danger is required. And I think that's too late because the individual could end up harming themselves or others or commit a criminal violation. So that's one concern I have. The other concern I have is there's no discussion around the concept of psychiatric deterioration as a standard. While I'm not a medical professional, I've been educated enough by them to know that some conditions affect judgment and actively destroy brain cells. And I think we need to somehow recognize that. Otherwise, we could perpetuate the lack of clarity that we're experiencing now that's leaving a large segment of the mentally ill population untreated.
Thank you, Delegate Lewis Young. I don't know if you want me to respond or just make sure that I record your concerns.
Either. If this is something that the group has discussed, I'd be happy to hear their thoughts on it. But if it's not something that came up for discussion, I'd certainly like you all to give it further thought.
And I will say, Delegate Young, that your comments were certainly part of those that were included in the work group. Debated, as you know, this is a topic that has a lot of views and concerns about it. So I will tell you that's why we ensured in the beginning. I'm sure you are aware that the stakeholder group was wide and diverse. So your statement was absolutely reflected in that discussion, and I think as many work groups have to balance these very important opinions and very, very vital concerns and weigh that and try to come up with a balance. To your point, we still have an open comment period. But I do want to thank you so much for offering that and asking if indeed the work group had discussed, because it does give me the opportunity to share that information more explicitly than it was.
Thank you.
Senator Eckhart.
Thank you very much. And is it possible, Dr. Burgess, to go back to the previous slide? I wondered if A, B, and C attempted to capture the deterioration that Delegate Young had talked about. Can you respond to that? I mean, when it talks about the individual has behaved in a manner that indicates they are unable, without the assistance of others, to meet their need for nourishment, medical care, shelter, protection, and safety, that they have a risk for bodily harm, serious illness, or death. Was some of that part of the discussion as further clarification on deterioration?
Thank you so much, Senator Eckert, for allowing me to further clarify this discussion. As you can tell, it certainly is one that is robust. But to your point, that could absolutely reflect that continuum, that a patient, for example, is functioning at a particular level. And again, this is not the only example that could be used, but all of a sudden, because of delusion, stopped taking their insulin, for example, and that puts them at risk. So that is a change in functioning. My response to the Delegate Lewis was that the exact words are not used, but to your point, one could encapsulate that concern. That a change in functioning is reflected in the language. Does that answer your question?
Yes, it does. Thank you very much. Because I was thinking, as I look at that could pertain to a number of different situations. Somebody who had gross dementia or schizophrenia or mania. There are just a number of diagnostic categories that some of the behaviors would indicate that there was, in fact, deterioration or further progression of the illness that would need intervention above the individual's volition in seeking and obtaining that. Thank you.
Absolutely. Thank you, Senator Eckert. Dr. Trapurani.
Yeah, hi. Hi, Dr. Burgess. Thank you for your presentation. I just have a comment and a suggestion. On section 3C, I was wondering there could be some verbiage that can be incorporated that references to non-compliance to treatment, because I don't see anywhere else a non-compliance to treatment. A lot of the schizophrenics and bipolars, when they are decompensating, wherein they are putting themselves into risk, is really related to non-compliance to treatment. If that could be somehow incorporated into the language, that might address some of the concerns that were already addressed, brought up in this meeting.
Your lost connect. They're back on.
They're back on again?
Yeah. Oh, yeah.
Yeah, we got back on.
Your point is well taken.
Is the LG missing?
Just let me do it.
Your point is well taken. Obviously, it's something that unfortunately we do find, and certainly we won't be able to have a full discussion. But I do want to just touch a little bit on that because again, the comment period will be open. But I would ask that we consider the issue that non-compliance in and of itself would not necessarily end in a patient presenting as indicated in C. And so I think that the outcome of that, certainly the key compensation, is what the language is trying to capture. You probably have had this experience that we can become very concerned if a patient doesn't take their medication, and not that we're misguided, but we're so concerned that we may want to commit a patient based on that, but the patient hasn't really decompensated. And so the language, it tries to capture the concern, the outcome. Certainly, to your point, the ideal, depending on which side you're on, would be to capture on the front end, to be proactive. But again, balancing the multiple feedback from the work groups, we had to decide, okay, at what point can we say that you need to fit the criteria for involuntary commitment. So I would ask that again, within the context of the comment period will be open, that we consider that perhaps the language of the non-compliance itself perhaps would be benefit from being expanded to the consequence of that action.
They get.
So, Doctor, with that, and again, please remember, if that doesn't answer your question, the comments will be open until August and August 12th. And so we're certainly open to having look at those comments so that we can ensure that your voices are heard. And I very much appreciate that point. Thank you. Am I missing anybody's hand, or is that? I would like to see more structure for seeking. For seeking voluntary treatment. Thank you for that comment. So, Lieutenant Governor, unless I'm missing someone, is in pre-commitment treatment. Oh, okay, thank you for clarification. I think those are all of the questions that I have. So I will turn it back over to you, Lieutenant Governor.
Is he back?
Yes.
Hey, I'm back.
Oh, great. There you go, Lieutenant Governor.
We're alive here.
All right.
Yeah, it's strange. We had a power surge a couple of times, and then it just dropped all of our internet. And so the internet just came back a few minutes ago, which took out our phones. Our phones are back now, too. So we were just kind of isolated here. And it's not a storm out there. I really think, I don't know for sure, but there's a lot of construction going on down here. The State House has work being done. Legislative Services building is about to be torn down, and so they're doing some work there. And then this is where I really think it happened is the city is replacing a number of sewer pipes, which I think also our phone lines and power lines go through, and they probably jostled those, and that's why we got the power surge, and then eventually took our internet out for a period of time. So they probably it looks like they didn't cut the line; they just might have jostled it enough that it just created some problems with our internet. So if everyone's willing, we can pick up where we left off. It was in the presentation.
LG, I just want to comment that several people have texted me that because of the storm, their power is out.
Oh.
I don't know how many that is. I wasn't counting head count.
Okay. Well, what do people want to do? We want to try to just reschedule this whole thing and go directly. If we reschedule, we go directly to the presentations. We don't need to do preliminary, updates of the committees. But I'm willing if the members, feel that we should just reschedule so that more people can be involved, since I guess we haven't gotten the storm in Annapolis yet, but I guess some parts of the state is storming. Barbara, is it storming there in Howard County?
No, we're okay here. It was Hartford, further north.
Okay.
Cecil County, whatever.
Lieutenant Governor, if I might add, in your absence, there was still a fair amount of interest and discussion in the danger standard regulations. And
okay, then let's go forward then and pick up where we left off.
Yeah. So we had Dr. Burgess. She's gone through the timeline.
Yes.
August 12th, September 12th, November 12th, and discussed the comment period. Though Young offered some observations, there was a number of other comments. I think we wanted to make sure you had a chance to.
Pat, they're back up. I'm going to call you on your cell. It's 4:54.
Yeah. So, Lieutenant Governor, I wanted to make sure you had an opportunity to weigh in on your observations in the evolution of this dangerousness standard, if you were so inclined.
Well, I know that there were, the stakeholder meetings that Dr. Jones, when she was here, was holding. There are parties that, want to go further in terms of, addressing the issue and don't feel that at least proposed regulations go as far as they'd like it to go. And then there are others who felt that this was, a step in the right direction, but they didn't want to go as far as what some other states. And I know Barbara had sent some information, at least to us this morning, that Louisiana had included psychiatric deterioration in their danger standard, and that bill was just signed by the governor there. And Ohio is, I guess, debating it right now. So it's approximately 24 states that include that in their danger standard. And it's something to look at because I still have some concerns, just personally, I'm not a professional, in terms of just being able to really address those individuals who cannot care for themselves. And that's what early on when we first started this commission, I voiced that concern that there are a lot of individuals, and particularly adult children, so the families are still trying to grapple with these folks that are, considered competent, in the eyes of the laws, whereas when they were below 18, they weren't competent in many cases. They weren't competent because they were minor, but also they had severe mental illness. And then all of a sudden at 18, they're competent to make certain decisions that they really, really wouldn't be able to. They wouldn't be able to be deposed because they would be considered, that they're questionable in terms of their competence to stand trial or to be deposed, to take in certain, legal matters at that time, sign contracts, but they're competent to make these decisions. So I still have some concerns personally with regard to being able to address those individuals that are really presenting a danger to themselves and others. Now, I know Dr. Jones had talked about, because when we were talking about this at one point, when there were a couple of issues or incidents that occurred in Baltimore County, one where, and we had the Baltimore County Health Director or Commissioner in, along with the Chief of Police, and we were talking about, they came in actually, I think it was the week after the individual out there had set fire to the townhouse community and came out and actually shot one or more people as well, who had been threatening people in the community for a while. And clearly this individual had severe mental health issues. He, progressed in terms of his aggressiveness, and it resulted in this. And the police had been called previously, but they just didn't have, in their mind, they didn't feel they had the authority to take him in for a psychiatric evaluation or anything of that nature. So I just, I don't know that these regulations would address that. I think Dr. Jones felt that it would address this type of concern. But I just a little concerned about that. And I know we talked about AOT. AOT, I think, is a little different because you really have a person that, is going into the situation, maybe involuntarily, but they at least are agreeing to certain restrictions, and the court is enforcing it. And I do support, AOT as well. But we're just talking about the danger standard at this point, and we'll come back to AOT. Dennis, that's at least my understanding
Thank you,
of what's been
Lieutenant
going
Governor.
on the last couple of years.
I know when we talked about this over the last few months, getting ready for this meeting and the printing, I think what you said earlier is we wanted to, because this had not been dealt with, we wanted to have something that we could get into the regulatory review and get into a comment period so that we didn't, if we kept stalling because we didn't have something perfect, it might never get done. So I think the idea was, let's get something that's in the middle and put it out there, knowing that we're going to get comments on both sides. Some saying it doesn't go far enough, others saying no, it's gone too far, and trying to balance those points of view.
Yeah, no, I understand that. We can't let the perfect be the enemy of good. So
I just want to add, Lieutenant Governor and Secretary, to your points, trying to make that balance, right, of using words that could be interpreted different ways and trying to reflect the spirit of what we are looking for decompensation, right? That we're looking for that which was the individual at risk of being at harm or others of being at harm, and that continuum of what decompensation looks like. From the first, not sleeping well is that decompensation. So I think that I am impressed with the way that the work group had to tackle that very difficult paradigm. I coming in on this, looking at it again, hearing the members' comments, and I'm reading it yet again. I've read this multiple times, had multiple conversations, and I think that balance for right now was well struck.
So, Lieutenant Governor, I think we'll get this moving forward, get the comment period started. We'll have a month for comments once it's published, and then we'll take another whack at this, once the comment period. So there's plenty of time to review and contemplate the comments once they come.
No, it'll be interesting to see the comments as they come in, and I know we have a number of people who are going to testify. We're going to, issue statements today, and I'm quite sure a couple are going to be expressing either support or concern about the proposed regulation. And I suggest for them to make sure that they submit comments, valid, well-reasoned comments, because they will be considered as we go forward with the regulations. And as well as continue to participate in the legislative process going forward with AOT and others codifying these positions.
The other thing, Lieutenant Governor, the nice thing is that our next meeting's on the 13th of September. The comment period ends on the 12th. So we'll have we'll have the benefit of a full set of 1 month's worth of comments by then, so.
Absolutely. Thank you, Secretary and Lieutenant Governor.
Yeah. So that's all we have for today, Lieutenant Governor. Back to
Okay,
you.
any other questions or comments with regard to the presentation? Okay, I guess at this point, we'll turn to the public testimony. And we can start with Evelyn Burton.
Okay, thank you very much. I'm Evelyn Burton. I'm the Maryland Advocacy Chair for Schizophrenia and Psychosis Action Alliance. And I'm here today on behalf of family members with those with psychotic illnesses and individuals with psychotic illness to ask for revisions to the proposed danger standard regulations and to ask that the commission members seriously consider these revisions and make comments on them now. Behind me stands an invisible army of family members. Some are not here today because they could not get their loved ones with psychosis into a hospital for desperately needed treatment. And they are afraid that if they testify, their psychotic loved one could harm them or cut off communication so that they could not be helped. They want 3 changes to these proposed regulations in order to remove the barriers to hospital treatment. Explicit language that imminent danger is not required. That was what the commission was first concerned about. There's nothing in these regulations to make that clear. And I'm afraid without that, the common interpretation will continue. We need a requirement that, like with every other illness, personal, medical, and psychiatric history be considered. Many other states require this. There's no reason I can think of that it shouldn't be included. A psychiatric deterioration standard to enable access to hospital treatment for those experiencing psychosis and psychiatric deterioration before they become seriously ill physically or die by suicide or end up incarcerated. I know Dr. Burgess was not at the meetings, but I'll say that I was. And if you read the report carefully, it makes very clear that the administration does not believe that these standards that are proposed will include any form of psychiatric deterioration. It was specifically rejected. Serious illness does not include psychiatric illness in their interpretation, and neither does any psychosis. They acknowledge that psychosis can cause brain damage and destroy cells, and yet the report claims that you can have psychiatric deterioration without danger. Psychosis is a danger in and of itself, and it should be specifically included in there because it was very clear to me as a stakeholder that the department would not do their training so that these regulations include any form of psychiatric deterioration. So that's why it needs to be made explicitly clear. And as far as trying to find a balance, they are balancing it off the lives of our loved ones. In order to achieve this political agreement and avoid political repercussions, they're coming up with this balance that does not solve the problem. They're saying to us that your loved ones are out of luck until they get so seriously ill or attempt suicide. We're not going to help them. They can be psychotic for months and months and years, and your family's life could be in danger and their life could be in danger, but we're not going to help them. And that's what's been said, and that's what these regulations still say.
Ms. Burton, thank you. And, please submit your comments. And as I mentioned, I have some concerns about it also, and I noted down those 3 areas that you were concerned about. And I particularly think that whole question of imminent danger is something that, that has been a problem with the current interpretation. And looking at the history is something that should be considered as well. So, please get your comments in, and others who are willing to comment and able to comment. I agree with you. Yeah, I'm not going to say it was a political decision, with the big P of political, because I'm not running again. I don't have that issue in terms of, favor to a constituency or another constituency. I'm just trying to do what is best. And as the secretary said, this is just, what they propose is a step in what, to possibly lead to something that is better. So put in those comments. This is not final. This is just a draft. And I'm sure that at least I will take them very seriously and see what we can do to address some of these concerns that are out there. We have Ms. Newman, Laura Newman.
Yes, hi.
Hello.
Hi, I'm a consumer of mental health services. I'm also a legal intern and law student. I'm currently at Disability Rights Maryland for the summer.
Okay.
And I just wanted to comment that when people are forced into treatment, a lot of times it doesn't work and they're put on medications that endanger their somatic health, and do not, it typically met with, it was met for me with not wanting to take medication, not wanting to be engaged in my treatment. And it really took a long time for me to realize that there was life beyond being with psychosis. But I would just really like to mention that if there was options to engage in treatment that weren't forced, I feel like that would be a more effective way. And like crisis intervention teams, I think are an excellent outcome that we've been seeing increase. But, typically when police are involved, it's a very combative environment.
No, I mean, I agree with your general point. And, for some individuals, it does work out, particularly like you said, crisis intervention teams. We've discussed for a long time the fact that once you get law enforcement involved, it escalates the whole situation. And law enforcement always has to protect their weapon. So if there's any issue associated with that weapon being grabbed or an attempt to grab it, it really gets to be difficult. But it escalates as soon as they get involved. And so some communities have been sending law enforcement along with a professional in behavioral health or in social work to try to make sure they de-escalate. And now understand, law enforcement is being called, or a health department is being called, normally because a family member is concerned about their child, and in many cases an adult child. And so, and not knowing the situation, we've had situations where the person, the adult family member has become violent. And so it's, you need to have that combination going out there. And as well, law enforcement is one of the few 24-hour, 7-day-a-week operations out there. So, I mean, you're absolutely right that it increases the level of escalates the situation when they're called. And so some counties have been trying to address that in a different way. And there are crisis response teams out there. A lot of what we're talking about is the person who is in crisis and cannot make decisions for themselves. And they may, and in some cases, they may appear to be rational, but they really aren't, and they're not able to care for themselves and care for their others and their threats that are made. And so we have to find that balance of how we address the civil liberties side that you're talking about, but also the person who is a danger to themselves or others. So thank you very much, and please feel free to submit comments when that comment period is open on the danger standard.
Thank you. And I just have to say, excuse me for interrupting, that I'm not saying anything on behalf of Disability Rights Maryland. This is my personal opinion.
No, you as an individual, feel free.
Yes, thank you.
Dr. Burgess, you have your hand up.
Yes, I saw something in the chat regarding being able to find the regulations for comment. August 12th is when the proposed comment regulations are scheduled to be published in the Maryland Register.
Okay, thank you. Okay, all right. Karen Foxman. Karen Foxman.
Yes, thank you,
Oh,
Governor. Hi, how are you? I'm not testifying this evening.
Oh, you just said you'd be here. Okay.
Oh, yes, thank you.
Welcome.
Thank you very much.
Okay. Daniel Weinberg. I know we've had so many problems with our Zoom that maybe Daniel didn't come back. Daniel, let us know if you do pop in at some point. Laura, and I'm going to pronounce this the best way I can, Pugliano.
Hi, yes. I'm Laura Pugliano.
Oh, Pugliano.
Yeah, it's fine. I was the mother of a severely mentally ill young adult. He has passed away. He did not survive his illness, which was schizophrenia. And I would just like to make a short statement and say thank you also for listening to our testimony. On the 1st of April in 2012, my adult son announced he was crippled and went to bed in the middle of the day. He told me his ankle was pulverized, he had a brain tumor, his back was broken in 3 places. He promised to get up when he healed. After begging him to see his doctor, I left his bedroom and started sobbing. He had schizophrenia, a thought disorder that includes hallucinations, delusions, and paranoia. Before this event, he had quit taking a medicine called clozapine that is used for hard to treat cases. In the next 2 weeks, he quit eating and drinking. I cannot emphasize strongly enough how frightened I was for him. He couldn't trust anyone to bring him food. He saw poison being pumped into the water supply. He could only use the restroom with assistance. Then he quit trying and just urinated in his bed. He smelled, his clothes were turning black, his lips were crusted and cracked, his hair matted. I sat by his bed for 10 days, putting ice chips in his mouth and wiping his face, begging him to make a good decision for himself and let me take him to a doctor. Clearly, he was not capable. I began phoning crisis intervention teams during this time, both city and county, but no one would come because he had to give them permission and they couldn't judge if the danger was imminent without seeing him. There was no consideration given to his psychiatric history, including the history of needing 8 previous hospitalizations. He was sicker than he'd ever been. He really needed to get to a hospital. It started to dawn on me he could starve himself to death in his own bed if I somehow could not secure treatment. I went to the local courthouse and begged a judge for an emergency petition. The next morning, 12 days after the standoff started, the police helped him, shaking, weak, and filthy, into a squad car to go to the hospital. Once he got to the hospital, he refused medication, which he was allowed to do, even though he was refusing food and water. That was April 13th. On April 16th, An administrative law judge found him to be a danger to self and ordered him involuntarily admitted. At this point, he was in a wheelchair, still in his same clothes and unmedicated. On April 23rd, a week later, a medication panel decided that medication over objection was warranted. He was still in a wheelchair in the same filthy clothes, but now he was mute and catatonic. I'm going to repeat that. He was 20 years old and he became mute and catatonic. After a 48-hour appeal process on April 25th, he finally received an injection of an antipsychotic. Again, it started on April 1st, and on the 25th, he finally got medicine. He was discharged from the hospital 2 months after he was admitted. His thinking was much more rational and in reality, and he asked me, "Mom, what happened? How did I get here?" He also lost a total of 40 pounds. I support revisions to the danger standard to help young men like my son have a chance at recovery. Psychiatric deterioration is clearly a danger to self and should be added to the regulations, along with requiring consideration of personal, medical, and psychiatric history. And we need an explicit statement that the danger need not be imminent. Without this criteria, there was literally no way to intervene, which I am sure would have prevented the worst of this situation. We need to close the legal gaps that prevent parents like me from bringing a child to medical care. What should I have done as a mother when my son went to bed and tried to starve himself to death? If my son had any other brain dysfunction, I would be legally negligent and abusive in not seeking medical help. But with the same injured brain, with a psychiatric disability, I'm supporting a choice he makes to starve himself while delusional. In the end, as a mother and as a parent who counsels dozens of other parents in exactly this situation every single week in a support group, I know that revising the proposed danger standard is the humane answer to helping us help our children. Thank you for listening.
Thank you. And please submit your comments. That would be very helpful. And thank you. And sympathies on what you had to go through. But it's the example of kind of the things that I was touching on in terms of my concerns too.
I just want to make one more short statement, which is that I would like to thank every single person on this panel who is interested in this issue and interested in any kind of reform that will help these parents. They need your help so, so badly. Thank you.
Thank you. Okay, Lisa Daly.
Hello, I'm Lisa Daly. I'm the Executive Director of Treatment Advocacy Center. We're a national nonprofit with a focus on eliminating barriers to treatment for people with severe mental illness. And I am also a family member. I have a sibling with a severe mental illness who has been in a position to require involuntary care on a number of occasions. And she is now doing very well and is glad that she received involuntary care at the time that it was needed, although she did fight it at the time. When our organization published a review of civil commitment statutes in 2020, Maryland was one of only 6 states at the time that in the US that didn't provide a definition or concrete guidance for practitioners on what the legislature means when it says danger to self or others and where that term is used in civil commitment criteria. Within the past 2 years, 3 of these states, so Maryland, Oregon, and Texas, have been considering legislation that would provide that kind of a definition. And one, which is Alabama, passed a law defining danger. So we are basically in a situation where Maryland is now a significant minority among the states and not providing a definition. And the commission has received testimony from many stakeholders, family members, and practitioners advising that this is a problem and a significant barrier to treatment for those in the state. In response, the draft regulations that we've been discussing today are being considered to ensure timely, effective, and equitably applied intervention. And we commend the effort to address these life and death issues through these proposed regulations. We do feel, however, that it would be a missed opportunity to only partially address the acknowledged shortcomings of Maryland's criteria. So we therefore ask the commission to consider passing a resolution or at least continuing to consider the 3 additional inclusions to prevent some of the state's most vulnerable individuals from continuing to fall through the cracks out of treatment and then back into tragedy. So first, we ask the commission to make explicit that imminence is not a requirement for intervention. And I know it does not currently state in Maryland law that imminence is required, but I know a testimony has been received, and it appears to be continuing to be the case that individuals who are in a position of needing to make the determination about whether or not a person meet criteria appear to continue to sort of consider imminence to be a de facto requirement, even if it is not explicitly included in the criteria. So we ask the commission to consider passing a resolution calling that imminence be expressly made clear. It is not a requirement for a person to meet criteria. Due to the lack of definition of danger to self or others that exists in Maryland, the fact that imminence is continuing to be interpreted to be part of their criteria is leading to what really can be just described as a sort of unfortunate criminalization of psychiatric symptoms. Imminence of harm is not a desirable criterion for a number of reasons, but the one I want to particularly call your attention to is the relationship between a requirement for imminent harm and the likelihood of criminalizing these symptoms. It's a completely logical result if you think about it. If we require that a person be on the brink of violence, whether towards self or others, before we're willing to authorize intervention, the window of opportunity for the intervention to be medical or therapeutic rather than law enforcement or criminal justice oriented is very brief. This is even more true for families of color. If we wish to ensure that more people are treated than jailed, we have to make clear that for practitioners that imminent violence is not required. I know that in some places in Maryland, there are people who understand this, but it is not being evenly applied throughout the state. Secondly, we ask the commission to explicitly include the ability to consider a person's treatment and behavioral history and patterns in assessing whether the full picture of an individual's circumstances points to a need for intervention. Too often, a decision for life-saving intervention is made based on a tiny snapshot of time. Each time a person is evaluated for emergency and intervention, there's an opportunity for someone to be placed onto the path of recovery. We want that decision to be based on the most full understanding of whether that intervention is warranted. This is fully consistent with the practice of other states and the express language of their criteria, and I will provide examples from specific states in my written testimony to the commission. And finally, we ask the commission to include language in its proposed regulation making explicit that damage to a person's brain, continued psychosis, and ongoing psychiatric deterioration is a form of harmfulness to self. To be candid, this point appears to be often misstated or misrepresented, so I want to be clear in iterating that mental debilitation and psychiatric deterioration is harm to self, and a type of harm to self that can also lead to harm to others or to the public. And frankly, it should go without saying that a person whose mental illness prevents them from satisfying their own basic needs for survival or from protecting their own mind from irreversible damage does present a danger to their own life or safety. It should be included within Maryland's definition of dangerousness. This is fully consistent with the practice of other states, 27 of which have such a standard, with the 28th on the brink of adopting one. I will provide examples of states incorporating this language into my written remarks. Defining dangerous is not an expansion of the current commitment criteria. It's a clarification of them, bringing the law and regulation in line with court decisions in Maryland and providing necessary guidance to lay practitioners who are called upon routinely to decide whether or not a person standing in front of them meets criteria for intervention or not. I thank you for considering my testimony on this important issue, and I, as I said, will submit my written remarks by the deadline, and I am always happy to answer any questions if anyone has any questions about which states I'm talking about or what criteria I'm specifically mentioning. Thank you.
Thank you very much, and thank you for your testimony today, and please also submit testimony with regard to the proposed regulation. Okay, that, I just went through the list of those who had signed up to speak publicly. I'd like to ask, and I know Delegate Young is still with us. And Delegate, I know you had legislation for assisted outpatient treatment. And I didn't follow it carefully, but what happened? What happened to the legislation?
Well, it was controversial. That's the short story. We tried to make it less controversial by making it a test.
Right.
We were just going to test it in Frederick County. And we had the support of everyone in Frederick County, the county executive, the head of our health department, other legislators, and we had bipartisan support. Senator Huff cross-filed my bill. There was opposition from the usual sources. We gave a lot of examples of states that have successfully implemented this already. Way back as far as 1999, New York implemented Kendra's law, and now there's data because it exists in so many other states to show that you can reduce hospitalizations and arrests by as much as 74 to 87%. Also, SAMHSA did a study, and 92% of the participants claimed that they agreed it was a good program. So the opposition came from a couple of sources. One, those that still feel that it infringes on an individual's liberty, although we didn't make this mandatory. I mean, you can't force somebody into it. The courts were a bit concerned because they thought it would add extra volume, and there were questions about who would represent the individual. But we said we would work with the county to provide legal representation. So I would say it was the opposition was really a combination of the court system and those entities that feel that you are constraining rights. And as you know, with the legislative process, when there's too much opposition, a bill doesn't move forward, even though it was a local bill and the delegation supported it. I had recommended doing a study just to try to quantify how many people are falling through the cracks, how many people would qualify for this kind of situation, but it was kind of late in session.
Right.
There's some overlap with the whole dangerousness definition because obviously if we get a better definition, it might affect either the necessity or the delivery of AOT. So I would like to see these two efforts run, kind of parallel.
Okay. Was the opposition you were getting, was it from local folks in Frederick, or was it and that would have been what, it's.
Yeah, I think that
sad that the legislature wouldn't, give deference to the locals.
Exactly. And for those that were in opposition, we would have had a test, plenty of time to address concerns. Frederick was willing to take a risk, but, I think that there was concern that it might actually be successful.
Well, and the concern I have with the courts, first of all, I mean, they're supposed to handle these kinds of matters. Okay.
Right.
Now, there will be additional funding, as we just, mentioned. There's funding to come in if they need to bring in additional people, or we need to appoint, specific mental health judges. something of that nature to have a mental health court, that maybe it has jurisdiction in, particularly when you get to smaller counties, let's say, the Upper Shore, that they go across county lines. They don't, it doesn't have to be just in that county. But that's something that can be, worked on. But the concern about who's going to represent, I know if you go in, like Miss, I'm going to say her name wrong again, Pagliano, who just testified, when she went in and the judge made a determination that her son needed to be involuntarily committed. Normally, there is a representative that's appointed by the court to represent that individual. So that was a little disingenuous for, the court system to sit there and say, oh, who's going to represent these people? Well, you appoint people to do this, to handle those kinds of situations. You just do it the same way. So it's just, it is shameful. But I hope that once you become senator, well, I don't know if I'm supposed to say that, but that you'll continue this effort and go beyond because we appreciate it. And maybe some of the others who are, on this, committee as they continue their efforts. Delegate Kelly, I'm going to send her a letter because she's just hasn't been participating. I don't know what's going on with her. So, I think that there's a lot that can be done going forward.
Thank you. I really appreciate that.
Okay.
Yeah, I think if I might jump in.
Yes, please.
Thank you very much. Yeah, and I would support that effort too. We need a pilot to get a track record. The other piece, if I was going to ask one of the witness or the individuals for public comment, the use of the Mental Health Advance Directive is another initiative that was developed years ago that does set out a treatment plan of action that if we had it embedded in CRISP, it would be able to provide a guideline for how to intercede and provide treatment earlier in that process so that folks don't have to languish for at least another 3 weeks. So that is something I think to look into as well.
Okay, I think Deborah Bennett wanted to speak, and I think I called you first, but you weren't there at the time, so we went past you. So welcome back.
Thank you. Well, I apologize for not hearing. I've been on the whole time, and I clicked on the
I know.
link 3 times, so.
It's our fault. We were bounced on and off,
Yeah,
and then we had a power surge here. So
right, okay.
Please feel free.
Well, thank you. Good evening, committee members. I'm Deborah Bennett, a concerned parent, mental health advocate, and a family peer support specialist in Prince George's County. And as an aside, I'm a proponent of AOT. I'm giving my testimony to urge the commission to specifically recommend that the danger standard proposed by the health department be revised to make explicit the following. 1, the danger need not be imminent. 2, available personal, medical, and psychiatric history must be considered. 3, a danger of psychiatric deterioration is a form of danger to self. In June 2021, my 33-year-old son, who has a dual diagnosis, he has schizoaffective disorder, bipolar type mania with psychotic features, and also has a severe bilateral hearing impairment. He lived in Frederick. He experienced a psychiatric crisis with psychosis, and the police went to evaluate him after receiving a complaint from a neighborhood store about his demanding and bizarre behavior. His father and sister drove there on a Sunday night around 8:30 p.m., each 1.5 hours away, to try to convince the police to petition him for evaluation. They asked that his personal psychiatric history be considered, but to no avail. The police decided that exhibiting psychiatric behavior that he had did not meet the requirements of the danger statute. The mobile crisis unit was not available at that hour, and the court was closed. It was a Sunday. My son continued to deteriorate instead of getting treatment. Several days later, the resident manager called me frantically, reported that my son was laying in the parking lot. After we both called the Frederick police, he still was not petitioned for an evaluation. The following day, 3 residents complained about his unstable behavior. One filed a peace order, and the resident manager was compelled to issue him a notice to vacate because he was disturbing the peace. The narrow interpretation of the danger standard had not only denied my son crucial timely treatment, it created fear in the community and forced my son into homelessness. Homeless now for over a year, since last June. He was in a hospital in Baltimore City until about 4 o'clock today. And this is his third hospitalization this year and 17 plus prior ER inpatient crisis stabilization since 2020. Throughout this call, I've been getting calls indicating that he has discharged. He's in Baltimore City where they have an OCC. Me being a family peer support specialist, I reached out. I'm trying to connect the hospital to the program to him, but yet he was able to discharge and said he would go to a shelter. He was frail, psychotic, and a shell of himself, and his mental state has significantly deteriorated. He called me Sunday and asked me was I coming to visit him, and I did go. And I have never seen my son in this state. And as I'll say this again, he was frail, psychotic, a shell of himself, and his mental state has significantly deteriorated. Perhaps if the danger standard made explicitly clear the proposed 3 recommendations, my son would have received more timely treatment and stabilized before needing multiple hospitalizations. And I'll repeat, it is 17 plus since 2020, over $250,000 now, and he is still nowhere near to being stabilized. He suffered, before needing the multiple hospitalization, he suffered the tragedy of losing his mental stability, losing his housing, and being distant from his family. I urge the commission to please make the 3 recommendations to the governor because our loved ones deserve treatment before tragedy. Thank you for hearing my testimony.
Thank you very much. And I'm glad that we were able to bring you in.
Yes.
Kimberly Watts, you had some comments. Did you want to, mention them?
Yeah, actually, I guess I would particularly to Delegate Young say when you're crafting these bills, please do remember to include funding for people to represent these individuals in specialty courts. I work for the Public Defender's Office. I can share that we absolutely don't have the staff necessary to staff another specialty court. As it is in Frederick County already, we have to hire a panel attorney and outsource that for mental health court. So we would need funds to do that for an AOT court as well. Thank you.
I think, in terms of what I was talking about, those type of matters, I know some places like the District of Columbia, they outsource counsel for those types. They have basically counsel on call, and they're paid per case that they can bring them in just for those purposes. And in some cases, that might be a more efficient way because you have a person who's, that's specifically what they work on is those types of cases, and they get paid by the case. I'm not sure how they work it out on an hourly basis or just straight fee per case. But sometimes doing it through the contract is a good way to go for the individual counties and jurisdictions to represent those individuals.
And particularly,
yes, but it does require funding, like you said.
Right.
It would be up, and I think up to the individual county on how they would want to staff that.
Yeah, what I can say historically is that a lot of times specialty courts develop kind of organically, and we get voluntold to represent people.
I can see.
And we just don't always have staff to do that.
Yeah, no, that's a good point. Those elected officials.
Thank you.
Keep that in mind. Thank you. Okay, any other comments before we wrap up? Okay, well, this was very good. And I believe our next meeting is September 13th, which will be right after, I think, the close of the comment period for the danger standard. I will likely poll the members with regard to some of the suggestions that were made in the next week or so. to see if we do take a step officially, and I would imagine, Dr. Burgess, you can recuse yourself from any official comments that may come from the commission on this. And maybe even, I guess, Ms. Ricard, you're part of the health department too, so you may want to recuse yourself. It's up to you. But that's my intent, is to poll the numbers in terms of a position on the standard. So, or the proposed reg. So with that said, look forward to seeing everyone on September 13th. Anyone who wanted to submit comments, please feel free to submit comments to our website, which I don't remember what it is offhand. Mark or Ethan, do you know offhand the website? I think it's MV. Did we lose Mark? He's probably looking it up. In any event, we'll send it out. We'll send it out. So, okay. Thank you, everyone. Unless there's any closing comments. Hearing none, thank you.
It's raining in Ellicott City now, so.
Oh, raining in Ellicott City, okay. And that'll be my direction.
Yeah.
So
safe journeys, everybody.
Okay, thank you all. Thanks to everyone who testified too.
Yep.
Thank you.